Now 49, 18 years out from the conviction that put him on death row, Scott Peterson is waiting to learn if he will have a chance at freedom. The hearing that can earn the Modesto man a new trial ended with closing arguments Thursday, and now Judge Ann Christine Masulo has 90 days to make her ruling. Peterson right now stands convicted of killing his wife Lacey and their unborn child Connor. The remains found floating in the San Francisco Bay near where he said he'd gone fishing right before Christmas 2002. So did his defense team make the case? For that, we turn to defense attorney Michelle Trigger. Good morning to you.
Good morning.
So did his defense team make the case? If you were Judge Masulo, does he get a new trial?
I think it's a possibility. I think that both sides made excellent arguments. I watched both sides and remained pretty intrigued during the entirety of the arguments because ultimately the prosecution does have the burden here. They have to demonstrate if there was some juror misconduct that it was not prejudicial. And I think the defense did an excellent job establishing that there was sort of prima facie juror misconduct. We do have a juror who appears to have provided incorrect information. Specifically, she provided information she'd never been a crime victim, she'd never been involved in a lawsuit. Both of those things were untrue. She was actually involved in both. It also involved domestic violence. So I do think that it could go either way here. And I think that he does have a shot, which I think is going to be heartbreaking for many to hear. But ultimately, this was potentially very egregious juror misconduct.
All right, let's talk about that a little bit more. This quest, as you mentioned, for a new trial has focused on the juror who has been called Strawberry Shortcake by critics because of her over-dyed red hair. Her actual name is Rochelle Nice, and they say that she intentionally misled the court with her 163-page juror questionnaire. Misled in that one question, as you mentioned, about things that could prejudice her against Peterson. She wasn't honest. This was obviously a case about violence against a pregnant woman. Nice didn't reveal that she had been harassed by a partner and their new girlfriend when she was pregnant. She didn't say yes that she had been a victim. Maybe she didn't consider herself a victim per se. Peterson's defense team also brought up that that juror wrote to their client often after he was convicted and sent to jail. I don't know that that necessarily shows that there was bias in her decision making during trial, but how odd is that? Have you had that happen to clients that you've defended?
No, that is very odd to have a juror actually communicating with somebody that they sat in their trial for is very, very unusual. I wouldn't say that it never happens because jurors often get very invested. I've had jurors return to hear a sentencing. I've had jurors reach out to me to ask additional questions about what's going to happen to my client in the future, but I'm not aware of any juror actually reaching out by way of letter directly to my defendant. So that was very interesting to many people, but I have to say it's probably legally irrelevant because that would be conduct she did far after the trial, after her jury questionnaire. Really, the relevant arguments are going to center on whether or not that questionnaire provided false information. But you made a good point because ultimately jury questionnaires, they can be written in such a way that jurors can interpret them differently. So if someone says, have you ever been a crime victim? And you don't consider yourself a crime victim because you never called police, or perhaps the person was never arrested or charged, that could be fair, right? Other people would say, if someone stole, my lunch in fourth grade, I was a crime victim. And I run in that quite frankly all the time with jurors. That's why the follow-up questions are very important to make sure that you're actually getting the detailed information that you're looking for.
Got it. Well, in his push for a new trial, Peterson's attorneys also attacked this juror for refusing to speak with their team way back in 2015 and for only doing so last year once she was granted immunity from prosecution. If another jury was deciding on a new trial for Scott Peterson, I think the request for immunity would sway regular folks significantly because a lot of people might think, oh, well, you wouldn't need to ask for immunity if you weren't maybe guilty. But this will be chewed over in a judge's legal mind. So, well, she asked for immunity, may be regarded differently there, right?
Absolutely. Ultimately, jurors are under no obligation whatsoever to speak with anyone after their service is concluded. They can, but they're not obligated to do so. So I do think it's unfair to say any juror who speaks to parties after the fact, who speaks to the media, who speaks to even the defendant or witnesses is engaging in uncooperative conduct simply because they don't speak with them. I just think that's unfair. They're not under any obligation to do so. With that being said, You're absolutely right. The perception here is that she sought immunity before she wanted to really speak, but she lawyered up, and that's usually advisable. And if I was her attorney, I would have told her the same thing, because she could be potentially exposing herself to perjury charges or something of that nature. And ultimately, you would want to make sure, in an abundance of caution, that you're protected from those if you are going to continue to speak. So it does not look good, but ultimately, I think any lawyer that was competent in criminal defense would have told her, look, if you're going to continue to speak on that, which you're not obligated to do, let's make sure that you are shielded by an immunity agreement.
Alrighty, we're almost out of time. Just quickly, 90 days this judge has to decide in this case. Do you think it'll take the whole 90 days, or do you think we'll get a decision sooner?
I think she's going to take probably the entire 90 days. She's allowed the lawyers to submit additional briefing. I believe the deadline is September 16th to do that. At that point, and I guarantee that briefing is going to be substantial based on the complexity of the arguments here, I think she's going to really make sure that she not only reads those additional supplements, but she takes her time to write a very well-informed decision, because the entire nation is going to be analyzing this decision.
Definitely. As you said, it's the entire nation looking at this. Thank you, Michelle Trigger, so very much. I appreciate you.
Thank you.